Viewers, welcome back to the show. Before the break, we're talking about this interesting case of NIL and Ambulance Services of New South Wales. Don, you're giving us the facts. Just recap on what you were saying before.
So it was police found this person on the road, who was a plaintiff, and apparently been assaulted, hit over the head. Ambulance were called, couldn't treat him because he refused it, so they let him go into police custody. He went into police custody, and it was found out later on that he had a significant head injury, causing bleeding to the brain and resulting in significant cognitive and significant injuries all around.
Nonce, in the first instance, the district court judge, which is like our county court, found in favour of this person, didn't they?
Yeah, they found in favour of the plaintiff against the ambulance, but not against the police. They found that the ambulance effectively should have relayed to the police that, look, this guy needed some treatment and had to go to hospital. The background to this case, Tony, is that under the Intoxicated Persons Act in New South Wales, the police, one, have a right to detain the plaintiff, but two, also to force him to get medical treatment, unlike the ambulance. But they say that the ambulance should have told the police, this guy needs some treatment ASAP, and do nothing about it. So the police got away with it first instance. But
the court did find that the ambulance service had breached their duty of care.
Yep, they said they should have advised the police that he needed treatment.
And that's notwithstanding the fact that this fellow refused treatment.
Exactly right. So
Don?
Yeah, well, that was at first instance at the trial. Exactly right. I mean, despite the fact that the plaintiff refused and started waving around and shooing away, just pushing away the ambulance officers, I think they were indicating that it should have done a lot more than just say, well, we can't help him, or even just tell the police he needs to go to hospital.
Well, this was appealed to the Court of Appeal.
Yep.
And what happened there, though?
Well, Court of Appeal took a different view. Court of Appeal did say about the ambulance officer that they did owe a duty of care to look after this person. However, they said that the plaintiff failed to show that there was a breach of the duty, and they failed to show it because he refused to have the treatment. And
they went further by saying that even if he was taken to hospital, he would have refused treatment anyway, and they said that if he did so at the hospital, they couldn't do nothing about that, so the outcome wouldn't have been any different.
In a case like this, viewers, what's important is that the plaintiff must show that it's more likely than not that if the negligence had not occurred, the outcome would have been different.
As Don said before, he's waving the ambulance officers away, and despite 3 or 4 attempts, he still wouldn't allow them to touch him.
Why don't we go on to the next case of Worley? Who wants to give me the facts of this one?
Oh, look, I will this time. This is a case in which an Australia Post employee was stung by a bee, so he went back to the Australia Post headquarters, was struggling when he returned, so they called the ambulance. Ambulance arrived and they administered him some adrenaline. And basically the short and sharp of it is that as a result of that, he suffered a fairly, I think, it was a fractured hematoma.
It was like a stroke.
Yeah, like a stroke because of the adrenaline that was administered. And this plaintiff then sued the ambulance.
Well, Nonce was administered adrenaline on 4 occasions, I think.
Yeah, because that was a process that was, the ambulance were advised on how to administer it and the times and lapses to do so. But that was the basis on which he took action against the ambulance.
Don, what else is significant about the facts of his case?
Okay, so this happened in 1998, I believe, Tony. So they brought into question that the protocols that the ambulance officers were following regarding the administration of adrenaline, and it was regarding whether or not it should have been like an injection in the muscles, a muscular injection, or an IV, and they decided to put an IV on this patient, which ended up being too much and caused these injuries. So the court looked at every protocol to see if, the ambulance officers were following the protocol and if the ambulance officers were liable. But ultimately they found that because the ambulance officers followed the protocol step by step, they would not have been liable.
Well, Don, before that, in the first instance, the court looked at the issue of in extremis, you know, in extreme situations. So they went to the Oxford Dictionary and they looked at what that meant and if it was a matter of life and death.
At the point.
And Justice Barr found for the plaintiff.
At the first instance, yeah.
Yeah, and in the Court of Appeal, they overturned that decision, didn't they?
Yeah. There was uncertainty as, you know, what does at the point of death really mean, and, you know, when should and should not have been administered, and that was a lot of the debate, but ultimately the court's argument was that this particular ambulance officer followed the protocol, followed what needed to be done, and it was just an unlucky reaction, I suppose you could say.
And you have to look at what I guess the procedure was as a whole in terms of whether or not a person is liable. So it's not just to say that that protocol is wrong. They had to look at, okay, what is the accepted practice throughout Australia at that time? Not now, back in 1998.
Well, Don, you hit that on the head, because what the Court of Appeal said, that the paramedic had applied the protocols he had been trained to do so in circumstances where it was intended, they would be applied. There could be no negligence in those circumstances. But where the court was also critical was that the parties on both sides argued the case on expert medical opinion rather than paramedics or other experts in the administration of care. Yeah. So both parties got it wrong. Instead of getting expert paramedics, they tried to get expert surgeons to give evidence.
So it really
wasn't not the way to do it.
Wasn't on point. But just quickly though, it was unlucky because I think the verdict at the first instance was about $2 million, and obviously it went down to zero on the appeal.
Well, Don, doesn't it mean that in these circumstances, if an ambulance officer follows protocols and administers the treatment according to the way they've been trained, you've really got little chance of success, even if you get a bad result?
Yeah, potentially against the officers, but if the protocol was wrong, then you've got to...
Well, that's going to be pretty hard to prove. Yeah,
exactly right.
Nuns, Don, thanks for coming on board tonight.
Thanks, Tony. Thanks, viewers.
Thanks, Tony. Thanks, viewers.
Viewers, thanks for watching the show. Stay tuned for future episodes, and always remember to stay safe.